Hello, and welcome to Williams Mullins Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Bryden DeWitt, and today I'm going to share an update on some of the litigation regarding forfeitures in retirement plans. Over the last 2 to 3 years, there have been over 30 class action lawsuits claiming that the use of forfeitures to offset future employer contributions under a retirement plan violates ERISA's fiduciary duty and anti-inurement requirements. This litigation is occurring at the same time that the IRS has issued proposed regulations regarding the use of forfeitures in retirement plans. Under those regulations, forfeitures must be used no later than 12 months following the end of the plan year in which the forfeitures are incurred. And the regulations from the IRS say that forfeitures may be used to pay plan administrative expenses, increase benefits in other participants' accounts, or reduce future employer contributions. But the reduction of future employer contributions is the problem that these plaintiffs are claiming exists with retirement plans. The plaintiffs in these lawsuits argue that using forfeitures to offset future employer contribution impermissibly basically enriches the plan sponsor. So instead of having to make a contribution out of its general assets to the plan sponsor is using forfeitures, plan assets in the plan to reduce the employer's obligation to fund the plan. And these plaintiffs are claiming that this is a breach of ERISA's duties of loyalty and prudence, and even claim that it's a prohibited transaction, that the alleged enrichment of the plan sponsor by using forfeitures, which are already in the plan, is an impermissible use of plan assets to enrich the plan sponsor. The defendants in these over 30 lawsuits have some pretty consistent arguments to counter these claims from the plaintiffs. They point out that using forfeitures to offset future employer contributions is specifically allowed by IRS regulations. They also point to the fact that employers decide how to design their plans. And so if a plan document allows employers to use forfeitures to offset future employer contributions, that's a settlor decision. That's a decision regarding the design of the plan, and they have the right to use the forfeitures in that manner. They claim that there's no breach of fiduciary duty by following the terms of the plan, and that using forfeitures to offset future contributions is not a transaction that could be a prohibited transaction. So basically, the issue here is that plan documents, and almost every 401k plan that I've reviewed has language that says that a plan sponsor may use forfeitures to either offset plan administrative expenses or reduce future employer contributions to the plan. And what the plaintiffs are saying is that plan fiduciaries that are given that choice in the plan document, when they choose to use forfeitures to offset future employer contributions, are doing so not out of loyalty to plan participants or to benefit plan participants, but to enrich the plan sponsor. That's their claim. So we have some litigation, some very recent litigation that kind of provides us some guidance on where the courts are going to go with these arguments. And the first one I'm going to discuss is Hutchins versus HP Inc. This was decided in the U.S. District of Northern California in 2025, this year. Here, Hewlett-Packard had a 401k plan with 3-year cliff vesting for matching contributions, and the plan had the typical language allowing forfeitures to be used to reduce employer contributions, to restore benefits previously forfeited, to pay plan expenses, or for any other permitted use. So plan fiduciaries were given discretion to choose among these options as to how forfeitures were to be used. If forfeitures were not used to pay plan administrative expenses, the expenses were charged to participants' accounts. And here, Hewlett-Packard was charging participants $34 per year for record-keeping services. The plaintiffs alleged that by choosing to use forfeitures to pay for future employer contributions instead of to offset plan expenses, that Hewlett-Packard violated ERISA's duty of loyalty and prudence and engaged in a prohibited transaction by using forfeitures to offset future employer contributions. Interestingly and helpfully, for plan sponsors. The court disagreed with the plaintiffs. The court found that there was no breach of ERISA fiduciary duty of loyalty and really accepted the defense argument that the plaintiffs were essentially arguing for an enhanced benefit. The plaintiff was basically arguing, according to the court, to create an additional benefit that in any year in which there were forfeitures, those forfeitures would necessarily be used to reduce administrative expenses for plan participants. And the court had some language that I think was very interesting. It said that ERISA requires fiduciaries to ensure that participants receive the full benefit promised by the plan, but not to maximize pecuniary benefits for individual plan participants. So the court is saying the duty of loyalty under ERISA requires plan fiduciaries to ensure that participants receive the benefits promised under the plan. It does not require plan fiduciaries to make decisions that fully advance the pecuniary interests of plan participants. And because the plan did not require forfeitures to be used to offset administrative expenses, doing so, the plaintiff's arguments that would require the plan fiduciaries to use the forfeitures in that way essentially was writing into the plan a new benefit. So the court rejected the breach of loyalty argument. The court also rejected the plaintiff's breach of prudence, duty of prudence argument, because the plaintiff failed to show that any process or procedure that the fiduciaries followed would have had a different result, that the plan participants received the benefits to which they were entitled under the terms of the plan, and the fiduciaries followed the terms of the plan. So there was no breach of ERISA's duty of prudence. And the court also found that there was no prohibited transaction because using plan assets to pay benefits, according to the court, is not a transaction. Plan assets were being used to pay benefits. They were being used in accordance with the terms of the plan. There was no risk of underfunding of participants' benefits, and that ERISA's prohibited transaction provisions only apply to transactions, that is, commercial bargains that present a special risk of plan underfunding or involve uses of plan assets that are potentially harmful to the plan. So the court completely rejected, dismissed the plaintiff's claims of ERISA fiduciary duty and breaches of prohibited transactions. That was in the Northern U.S. District Court for the Northern District of California. But if we go to the Southern California, there was a case decided in 2024 for the U.S. District Court of the Southern District of California that came to the opposite conclusion. This is Perez Curet versus Qualcomm Inc. And here the plan, just like in all the other plans I reviewed and the plan in the previous case, gave fiduciaries discretion to use forfeitures to pay plan expenses or to offset employer contributions. Qualcomm used the forfeitures to offset company contributions. In 2021, $1.2 million of forfeitures were used to offset employer contributions. And meanwhile, the participants paid $954,000 in administrative expenses. So here, the motion to dismiss was denied. The court agreed with the plaintiffs that they had plausibly alleged that the defendants had breached their ERISA fiduciary duty by reducing future employer contributions rather than paying expenses and consequently harming participants by letting the administrative expense charge fall on the participants rather than on the employer. So here in California, the Northern District of California this year and the Southern District of California last year are in disagreement. But I think the arguments for the Northern District of California in the more recent case are really persuasive and interesting. Nevertheless, there obviously isn't agreement among the courts as of yet as to whether the use of forfeitures to offset future employer contributions violates ERISA. So the next steps for a plan sponsor, plan fiduciaries, well, first review the plan document regarding the use of forfeitures. Some documents restrict forfeitures to be used for just paying plan administrative expenses. Some may only allow forfeitures to be used to offset employer contributions. Many allow both. And so if the plan gives discretion to use forfeitures to either offset future employer contributions or pay plan expenses, plan sponsors should consider amending the plan to take this decision off the table for plan fiduciaries. Make it a settlor decision, hardwired into the plan. If the plan sponsor wants forfeitures to be used to offset future employer contributions first, Write that into the plan. Provide an order of the use of forfeitures, that first forfeitures will be used to offset future employer contributions, and then any excess amount could be used to offset plan expenses. If it's written into the plan document and it's no longer a fiduciary decision, there is no risk of a breach of ERISA fiduciary duty. So that will wrap up our discussion of the recent litigation regarding the use of forfeitures in retirement plans. If you have any questions or suggestions for future episodes of this podcast, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.
This podcast contains general, condensed summaries of actual legal matters, statutes, and opinions for informational and educational purposes only. It is not meant to be and should not be construed as legal advice. Listeners with particular needs on specific issues should retain the services of competent counsel. For more information, please visit our website at www.williamsmullen.com or contact any member of our team.